jebo eja enya ababa bedra se amena wo kasa de eye Supreme Court omotumi e the rulings no ababa betu kwan mu a omotire se de anka abambaben oye no enye mra kwan so kura wamfa mra kwan so anka obabe hunu na ye because say abambaben omotire mu a oka other Ghanaians no ho.
And the Speaker of Parliament has no option but to comply. I mean, I think that we must stop giving with one hand and taking with the other.
I want to mean free Supreme Court achi e me ye no bi asa say no omotire mu say afenyo markings ono a na friend majority leader.
I am the majority leader. Don't say no, say it. You've been saying it consistently and I've been correcting you. The court has pronounced. Stop describing me as leader of MPP caucus.
Actually, me say MPP be maintaining omu seat no as majority war parliamentar ho asem ena me de ebrewa sabra me no kasa de lawyers no bi ababa be kasa che MPP lawyers omo ababa be kasa omo akere law nim clear omo che se parliament omo anyom na her law so se wo pe obi o her law so pa dia this is Supreme Court asabre de omo che se NDC for ebeko akomaintain omu a minority seat a che se asamwa abano ano edin na me do be bowram na machiro ensam kakra isi ho ene video to bi ayensa ka bebebo achiro no hunu normal ekoso no aha WhatsApp TV mesro ya no subscribe no turn on the notification bell uwia no like no share video no ede amaye o comment no na wo de ato comment section no ase ne edin komo ede efri ho no medase. So on the 13th of October, not August, October, and Speaker of Parliament, etumi emeki a year declaration be our Parliament House, a kofa who sensem by any idea. Now this particular issue, ya a buy a idea my home videos pa, and we to measure that a jai link no at the good description box nim. Ube to me aqua said ya beya young queer chippy into kokosha ube video ya. This particular video no better as your pie. I just say and no Supreme Court to me at whatever the case is, you know, or the inquiry anymore near the dension and it was Supreme Court to me at Nasia Omo a ruling 5-2. Not just say Omo can send the way, you know, I dare say MPP for no in your majority 5 and NDC for no F minority 2. Nina say a kwanya nanka your friend say abambaben ade Parliament House o fast one na enye ne kwan no a wo manya abotre akirikire mu na ena eye Chief Justice eye Gertrude dokono enye dokono na nso de wan hwe obi akosi deformation me pa chaw montweme hwe ne ye ne de deformation. The information of character ntino ye bibia na wa make it clear say eye pa enye dokono me pa cho eye Chief Justice Gertrude Torkornu em say afidie why clear yes atena se no watumi akirekire law num ama say yankrofo ya omote Parliament House me kire MPC so omunim law no kura because omunim law na ke ya de senka omo ntwetwe kura enche anu ti majority leader afenyo markets ejina mu ekire mu se se de omubu ato omuyem na omubu ato omuyem ne se de omo baba be resume na omo baba resume no de se $250 million bosia bi a omo epe nkrofo wa adwene ma dike ya video akansem kwande ko tie nsem ameka ye nam se ba be sinsem bi so a che se o mo ko parliament no makwa ko dis $250 million sa sika no ho enkomo a utimi say yes ene nkrofo be ma goodbye this time pa because che o mo che sa batu no so nenim de se bia umbe retain and say obidi ene ene ahodaso de pantie bia ma menka ne say o mu pese o mu da o mu hoso based on baby me kina me hwe ma de me need evidence
I just wanted clarity on this matter. We can only thank God, and also it's a moment for all of us to rally around the choice we made in 1992, democracy. Democracy requires decency, and that is the path the MPP majority caucus took to ensure that we do right to the law. Nothing more except to say that we expect our colleagues on the other side, including Mr. Speaker, to respect the outcome of this case so that we move on as a nation. All we have is the peace of the country. All we have is our democracy. And in West Africa and in Africa as a whole, Ghana shines in the eyes of the people in terms of democracy. So this is another feat we have achieved, and we must celebrate it. It's not a matter of MPP against NDC. It's a matter of constitutional, interpretation, and the court has given its verdict. We should all respect it and move on. Thank you very much. I think on the
Anoti afenyo markens ekasa wiye na na MPP for lawyer ogina mu twitwaji wo mu no ono nso edi tu dwa ekire mu se constitution na eda honom no e kan sempa na de owo emra ne so tumi no betumi akire emra no mu yie no se senior speaker of parliament o na mum no eye Supreme Court ono nso ekire mu ema mu da honom.
The way forward is for him. Please. What to do.
The interesting,
the Supreme Court is spoken.
The interesting thing about this matter is that as far back as 1968, after the first Republican Constitution, we decided as a nation, which can be seen by the proposals of the Constituent Assembly, that two things will happen. The first thing that we decided was that we will have the judiciary interpret the Constitution. In fact, they said two things. They wanted the judiciary to be the ultimate arbiter of what the Constitution says, and they also wanted the judiciary to be able to give advisory opinions. The people of Ghana rejected the second suggestion and said that the judiciary should not give advisory opinions, but the judiciary is the body that should interpret the Constitution. The second thing that is important in that entire the 1968 proposals was that they decided that Parliament would not be supreme. The supremacy of Parliament was not accepted. What they decided was that Parliament will be under the Constitution. And so all our constitutions since then have followed this position. In fact, the 1992 Constitution in Article 1 says that sovereignty lies in the people. That sovereignty was expressed when the people, through a referendum, voted to bring this Constitution into force. And the Constitution tells us that the supreme law of Ghana is the Constitution. Everybody else is under the Constitution. Nobody is above anybody. Everybody has his role. And so the fact that the Supreme Court interprets the Constitution does not mean that they are above anybody. In fact, there are judges sitting on the bench. One of them is my classmate. My juniors are on the bench. But once they go and sit there, even if it's my own child sitting there, I cannot but bow and give the person respect, not for the person, but for the office and for the law. And we expect every other Ghanaian to also respect the law. We don't all agree on what is said and what is done. There are several times that I've disagreed with what is said and what is done. But because of the respect for the rule of law, because of the respect for the Constitution, we just keep quiet and follow the law, hoping that if we don't agree, another opportunity will come that we'll be able to express ourselves. So what has happened today, we have not seen the reasons. We are happy because we came to court because we believed that the right thing was that the people had not by their action vacated their seats. So what has happened to them, we are happy about it. Tomorrow, the reasons will come out. And when the reasons come out, as lawyers, then we can look at the reasons and what the court has said, and then we can discuss it. In fact, the fact that the court has ruled in your favor does not mean that you agree with the reasons. You might decide that even the reasons some of the judges gave, you do not agree with it. Two of the judges talked about jurisdiction. We don't know what they said, so tomorrow we will know. And when we know, we will prepare to answer more questions in detail. But as was said by the leader, as far as I'm concerned, today democracy has won, constitutionalism has won.
And Bagbin has lost.
Nobody has lost. Democracy has won, constitutionalism has won, and nobody has lost. Every one of us is holding every position that we hold in trust for the people of Ghana. We don't hold it in our own capacity. When you are an MP, when you are a minister, when you are a president, when you are a speaker, when you are a chief justice, you hold it in trust for the people of Ghana, and you are under the law. Your time will come and you leave the position, and that is what we must all write. So the 4 MPs have been reinstated. They must come to Parliament. And as far as I'm concerned, if the status quo ante is brought back, then this whole dispute that people call him caucus leader, whatever, it should stop from today. We have a majority, which is MPP, and the majority leader is Honorable Alexander Afeyo Maki. It's as simple as that.
Now, one of you know, and another lawyer, Mrs. say, one also can MPP lawyers and no, a babacasa, actually, must say, oh, I dare not a cost of fine pa. Now, say, nam, because other Ghanaians, no, yeah, why ne power for nature say, and so ordinary Ghanaians. Say, not no, we say. MP for no muka other Ghanaians no including Speaker of Parliament. And the no say yes, Melana say. And the Speaker of Parliament, I will hear other Ghanaian no. And you can say to me, a famrano, edit to him. Now what done it and said they would see a penal. Now what done it and said they would see penal. Or also in some ever two just say Sabre no Speaker of Parliament also to me a boo a year Supreme Court ruling no because when him say a speaker so obumela. Into obetiasie. Na dia waka editor to ne say Speaker of Parliament enya dia so obetumi aye hwe e wo ruling you ho and I say yes any abakade.
There leaves no room for any argument whatsoever, and the majority decision, very big majority, clear majority, 5-2. It's not as if it was a narrow majority, 3-4 or 4-3, that anyone can say, well, there's some room for kind of review anything at all. But the point I'm making is that whenever the court speaks, it's such a clear and emphatic order. Even if it's a very narrow majority, that's the decision of the court, and that decision must be respected. And I'm saying that it will result in a degeneration of our society and a destruction of our democratic order for anybody at all to refuse to comply with orders of the Supreme Court. And I think that's non-negotiable. It's something that we must all respect. I have heard some statements by certain political actors to the effect that the case ought to be withdrawn and that there ought to be negotiation and all that. I'm quite surprised because indeed, firstly, I did not hear such expression of a willingness to negotiate and all, or maybe such instruction to the Speaker or direct suggestion to the Speaker for negotiation and all when the Speaker started embarking on this act. And I think that for me it's very important that the Supreme Court ruled upon this matter because it is something that had been occurring in this country. The tendency for it to occur really was there. The tendency for it to occur again was there. It was necessary that the Supreme Court came to this clear conclusion and determination of the matter, the meaning of Article 97, Clause 1, paragraphs G and H. And I think we must all respect it.
What do you expect to happen in Parliament?
I think the Speaker of Parliament himself, to start with, indicated in his address to the press last week that the case raised very serious legal issues. Those were serious legal issues and matters bordering on governance in the country. In fact, so I must express my utter shock at this refusal to even file a process. If indeed the Speaker of Parliament himself recognized that the matter raised serious legal issues, as he said to the media last week, where else would you address legal issues but in the court of law? Where else would you have such a definitive pronouncement on the so-called serious legal issues that the Speaker himself recognized in his press statement, done by the Supreme Court of Ghana? So as for the Speaker of Parliament, indeed, is law-abiding. I've known him for a very long time to comply with the decision of the Supreme Court. As I said, it is non-negotiable in every civilized society. When an order of the court is given, no matter how highly placed or lowly placed the court is, even if it's a magistrate's court, you have to obey until it is set aside.
Having seen the conclusion of this matter, would you say as an Attorney General that there's a need for a constitutional review?
What does it relate to this? The American Constitution itself, very thin, as we all know. Yet, the Supreme Court, that Constitution has survived over 200 years. I think that, of course, there are certain provisions in the Constitution that I think that ought to be amended, and I've expressed my views on it to the media. Article 78, Clause 1, which enjoins the President to appoint majority of his ministers from Parliament, ought to be amended. There ought to be that flexibility. I think that certain institutions, for example, the Electoral Commission, NCC, and what have you, the appointment of their heads has to be with the prior approval of Parliament. But I do not think that it calls for a complete overhaul of the Constitution. And indeed, this Constitution is very strong. And it is one Constitution which even goes as far as prescribing consequences of a failure to carry out the Supreme Court order. The Supreme Court order, the consequences are set out clearly in Article 2, clauses 3, 4, and 5 of the Constitution, that any person to whom an order of the Supreme Court is directed shall duly carry out same. And a failure to carry out such an order, of course, has the consequences of a criminal punishment. In the case of the president, will even result in the president and vice president will result in removal from office.
And finally, do you expect the Speaker of Parliament to recall Parliament on his own volition after this ruling, given that the court has spoken in such a manner?
Yeah, I think so. I mean, as I said, it's an emphatic determination by the court on the matter, and the Speaker of Parliament has no option but to comply. I mean, I think that we must stop giving with one hand and taking with the other. As I said, it really amounts to double standards and an exercise in contradiction for the Speaker of Parliament in his address to the media say that the case raises such serious legal issues and matters bordering on governance and all that, and then refuse to take back. So this country refuse to take part in the proceedings. I think in this country we must recognize some people for who they are and what they do. This hypocrisy and double standards must cease. The Supreme Court is the final arbiter on all matters in the country, including an interpretation of the Constitution. Indeed, it's the only court solely seeks registration to pronounce on the meaning of relevant provisions of the Constitution. And the Constitution means what the Supreme Court says it means, and nothing more. It is the same in America, and as I said, America, United Kingdom, and all advanced democracies, that is the order that they respect. There's no way a Supreme Court would give a decision in America or United Kingdom, and then the Prime Minister, apart from expressing his disagreement with the decision of the President of America, of course he has the freedom of expression to express his disagreement with the decision, but he has no option but to comply, and they usually comply, and that is it.
Attorney General, many have said that this decision or this judgment was to be expected, and that the judiciary seemed to be in bed with the executive. Can you address that?
I mean that. So first of all, some principles of law have been established well over decades. There is no principle of law argued in this matter which has not been established in this country. And indeed, if that's the case, then any case mounted which has in play those principles will be determined the same way. So I think that if there's indeed the rule of law, an element of it is predictability. It's not a case where a court of law will rule this way on account of the same principle of law, but rule another way on account of the same principle. So indeed there must be some element of predictability. And I'm saying that indeed these principles that we contended with in this matter are old principles. There's nothing new. And for those who are saying the court is acting a certain way and all that, the same people were those who were rejoicing when the Court of Appeal gave a decision acquitting their leader. Their leader was acquitted by the Court of Appeal. They were happy with it. And to date, he's able to make all those arguments in Parliament because he has been acquitted. And I did not raise any issue with that back to appeal. I did not say I'm not going to respect the decision of the court. I respect the decision of the court. And until the decision is set aside by a higher court, which is the Supreme Court, that decision will remain binding on all. So we must stop this hypocrisy and exercises in contradiction. As I said, that when our reaction or attitude to court rulings depends on how palatable we deem it. We cannot react to decisions based on how palatable we deem it, and that's exactly what is happening. Thank you very much.
And until so far, way and somewhere a free parliamentary house, Akoniaba DNA, that breaking indefiniteness, and no emu abbas. I just a sabrade a yes parliament house, resume. Eli cry. It's a move resume yambo chakra now. Many sure say a bear me one. Now, a MPP phone so say 250 million be as a man country with Siano. And no cry beshu moon cryama. Umu the pressure is parliament. And I say speaker so am now every parliament and atum said the bayum beko could do him. But whatever the case is, no, I wish I also be to make the again today at the comment section no as a nayedi and como eddy a free honum. Send a who really no is at the fire. A fair. And I said, drop to comment section ho. You be din komo every honum. Macro.